Yeah. Yeah, I know. Yeah. Effortless superiority is usually mine. There's a lot of sweat, tears there. I'm glad you liked the last paper. Yeah, I thought it would appeal to you. Yeah, good.
Please.
Yeah. It's too risky now. Anyone who's ever risky. Well, have to bring in some she's great, you know, she's on some happy herself this year. So she and her partner are about to get married, by the way. Is Japanese. They're spending a year together. So it's nice. Little sisters watching me again. Yeah, they're getting married first in New York City, kind of, no frills, bureaucratic wedding, and then we're going to Japan and we want to celebrate.
Yeah, no, I've read some of his papers, some of it, but just the type of projects he's choosing.
Yeah. Yeah, right.
Yeah.
She's got a postdoc. That's what keeps families together. Know the truth because they were right. On her own merits. Yeah, for now she's got a postdoc.
Hey, how are you? I'm pretty well. How are you? That's too low. Switch. That's probably the right thing. There's a big red button on it. Push that. The emergency button. See? If there's a big red button, generally you should just push it. Yeah. Policy.
So how is that?
You know, it's fine. It's a series of disappointments that one doesn't get enough of, but I think that's probably widely shared.
So, would you come this year to then tell you what you're trying to
Trying to like basically write a book,
Okay.
and it's happening, but it's
Okay.
just a lot slower than one expects. Because I have so much time, to make it more complex and more difficult as opposed to just doing it. So now that I feel like time is coming on, simplify, let my standards down.
Finally, the deadline.
That's right.
Terrific to see all of you here. I'm Danielle Allen, Director of the Edmund J. Saffer Center for Ethics, and I'm pleased to welcome you to our final public lecture of the year. It's astonishing that we're already at that point in the calendar, but so we are. The Saffer Center for the last 2 years has been focused intensively on the theme of political economies and justice. And as we did that work, it also became clear that you can't address the changing shape of the world's political economy and political economies without digging into questions of technology that affects issues of work, obviously, issues of how capital flows around the globe, a variety of things. Thank you, Michael. Appreciate it. And so we have, as we've been working on this theme, political economies and justice, also woven in some public lectures on the theme of artificial intelligence. So we were delighted to have Tina Eliassi-Rad last year give a lecture on this space, focused particularly on the judicial use of sort of bail and pre-release algorithms. And Cynthia Dwork, who, as you all know, was a key inventor of differential privacy, gave a fantastic lecture in the fall, and we've been eagerly awaiting Justice Cuellar to carry the conversation forward. All the more so because beginning next year, our leading theme will be the ethics of technological and biomedical innovation. So this theme is going to blossom and extend in numerous directions over the coming years. We'll start off next year's lecture series with Dean George Daley on subjects of biomedical innovation, the issues of CRISPR, gene editing, the recent events in China, and so forth will presumably be a part of what his lecture is focused on. So thank you for being our bridge from one theme to another. It's my pleasure to introduce Justice Mariano-Florentino Cuellar, who currently serves on the California Supreme Court, a position he took up in January 2015. Previously, he'd been the Stanley Morrison Professor of Law and Professor of Political Science at Stanford. He'd been a faculty member there since 2001. A fellow of the American Academy of Arts and Sciences, Justice Cuellar has also held leadership positions at Stanford, for example, at the Freeman Spogli, I still haven't said that right, Institute for International Studies. He also, however, is a public servant and has exhibited this in numerous ways. He spent time in the Department of Treasury early in his career and worked in the Obama White House as well. He worked as a special assistant to the president for justice and regulatory policy in 2009 to 2010. And in this capacity, he led the Domestic Policy Council staff responsible for civil and criminal justice, public health law and policy, immigration, bipartisan food safety issues, criminal sentencing reform legislation, and a variety of other important issues. He's also published widely, and his breadth is astonishing. I found it super interesting to pick up a couple of your articles on executive power today, and particularly to think about them in light of this morning's news. A naturalized U.S. citizen, Justice Cuellar was born in northern Mexico. He earned his BA degree here from Harvard, JD from Yale, PhD in political science from Stanford. And although we invited him, many moons ago, 18 or so moons ago, he's now also a member of the Harvard Board of Overseers and will be a member of the Harvard Corporation effective July 1st, continuing his public service here on behalf of all of us on this campus. So we're just thrilled to have you here speaking today on the subject of tensions and trade-offs in law, organization, and the design of ethically aligned artificial intelligence. Justice.
Thank you, Danielle, and thank you all of you for being here. It's a tremendous honor to have been invited, and I should tell you that it's particularly emotionally meaningful for me to be here because I used to live in Winthrop House, but I really kind of lived in the Kennedy School as an undergraduate, so I would come to events like this all the time, and I remember being where you are in the audience and hoping that the speaker would be interesting and that the remarks would be short. But I'm balancing that with the really rare privilege that Danielle has extended to me, which is to tell me that this is the kind of audience that can take a somewhat longer discussion, so I'll try to strike a reasonable balance. I'm also delighted that any of you were here at all, given that apropos of the title Danielle just read. There are 14 words in that title with 2 commas and the word organization, so I wouldn't have been surprised if only 5 people had shown up. But another name for the talk could have been Postcards from the Edge of an AI Future. And maybe that, or mentioning Ariana Grande, would have gotten an even bigger audience. But I want to just start by telling you one brief reflection I had just a little while ago as I thought about my last year or so in law school. So right around then, we're talking 1996, and the inimitable and quirky John Perry Barlow, part cattle rancher, part cyber libertarian activist, founder of the Electronic Frontier Foundation, and one-time Grateful Dead lyricist, released in Davos a certain document. And the title of the document was, and I quote, "A Declaration of the Independence of Cyberspace." 23 years and change later, his words can still have a mesmerizing quality, which maybe you've experienced if you read the document. It's powerful. He was intent on shooing away government organizations from the realm of cyberspace. And I can't do better than just to read you some of the words to give you a flavor of what he was getting at. Referring to governments, he writes as follows. "You have not engaged in our great and gathering conversation, nor did you create the wealth of our marketplaces. You do not know our culture, our ethics, or the unwritten codes that already provide our society more order than could be obtained by any of your impositions. You claim that there are problems among us that you need to solve. You use this claim as an excuse to invade our precincts. Many of these problems don't exist. Where there are real conflicts, where there are wrongs, we will identify them and address them by our means. We are forming our own social contract. This governance will arise according to the conditions of our world, not yours. Our world is different. Cyberspace consists of transactions, relationships, and thought itself, arrayed like a standing wave in the web of our communications. Ours is a world that is both everywhere and nowhere, but it is not where bodies live. We are creating a world that all may enter without privilege or prejudice accorded by race, economic power, military force, or station of birth. We are creating a world where anyone, anywhere, may express his or her beliefs, no matter how singular, without fear of being coerced into silence or conformity. Your legal concepts of property, expression, identity, movement, and context do not apply to us. They are based on matter, and there's no matter here. With all respect to its remarkable author, this language feels quite dated to me now. When, according to a credible market analysis from 2018, a single company controls over 90% of web searches in the United States, and if you want to guess, I'll give you a hint, it's in my home state. I doubt that any of us would be here if we thought the internet was an overhyped non-event in human history. At a minimum, I suspect most of us understand the boom in attention and artificial intelligence was born not only from easier and cheaper access to more computing power and innovations in the use of deep learning, reinforcement learning, and other machine learning techniques, but from the very internet that inspired John Perry Barlow's declaration. Yet it's striking how much the declaration seems disconnected from familiar phenomena that any sensible discussion of governance, technology, or artificial intelligence would take seriously. The enormous concentration of wealth, data, and computing power in a tiny handful of technology companies, many based in my home state. The fact that Barlow made his declaration in Davos, not Detroit. How our own desires for convenience or constant stimulation spur us to act in ways we later regret. How the placeless and post-political promise of the internet is given way to what appears to be an even greater concentration of wealth, education, and prosperity in a few regional knowledge hubs like Greater Boston or my home base of the Bay Area. The human vices our technologies primed along with the virtues it's enabled, and the continuing role of large, complex organizations like police forces, multinational corporations, universities, ride-hailing companies, and financial institutions to organize much of what happens in work, economics, and society. The Yale sociologist Chick Perot strikes me as a particularly thoughtful observer of such organizations. Someone reading his work closely wouldn't be surprised at the persistence of organizations in our lives and politics in a world that was ostensibly going to be about crowdsourcing and non-hierarchical peer-to-peer relationships. Perot's work points out that the United States is distinctive in the extent of economic power that's concentrated in a relatively small number of very large private organizations that skyrocketed in importance during and after the railroad era. And there was no good reason to think, an observer's work might think, that the internet, any more than many forms of AI, would fundamentally change that logic. Whether it's entirely right or not to assume that AI systems are going to pose problems familiar from the history of the internet or even capitalism, I think Perot is right to presume that organizations raise some of the most complicated, value-laden political conflicts in society today. With this as a point of departure, I want to talk about the contested terrain we encounter when we consider the role of laws and organizations in our lives. And I want to make the case that, in part because of the deep analogy between many forms of organization and the AI systems that are becoming so prevalent in our lives, any serious discussion of AI ethics and governance must traverse similarly contested terrain. That politics and organizations are central to any sensible understanding of AI. That the intellectual terrain belongs as much to Max Weber, Martin Luther King, and Judith Shklar as it does to Mark Zuckerberg, Bill Gates, and Elon Musk, is the crux of my argument. This theme is not entirely unfamiliar here at the Kennedy School or other places where the work of colleagues like Cliff Nass, the late Cliff Nass, and Sheila Jasnoff is read. But I want to make my case by telling you 4 brief stories that will help convey my own, perhaps somewhat quirky, take on this as somebody who has 1 foot in Silicon Valley and 1 foot outside it. Then I'll share a few tentative implications that might be especially relevant to government agencies and universities. Here's the first story. Driving to San Francisco recently, a certain California state official who used to work full-time at the university realizes that the driver behind him is in an electric vehicle that has some kind of automatic piloted gate. In these days of the 737 MAX and the driver just behind this state official engaged in personal grooming while the car drives itself, heading up 280 with Silicon Valley melding into San Francisco, it seems oddly bemusing to this state official that observers talk about self-driving vehicles as if they were in the future. Whatever the official limits of its capabilities, in mid-speed stop-and-go traffic, the ostensible driver of the electric car seems to have virtually no interaction with the steering wheel when the state official begins observing through his rearview mirror. As the state official observes the electric car's occupant, the person who is the ostensible driver is engaged in the mix of what looks like texting, distracted glancing out the window, and of course the personal grooming. Almost subconsciously, the state official realizes he's tweaking his own driving to test, within the limits of what's safe, of course, the way the algorithm drives the car behind. If I slowed down or applied the brakes, the electric car would slow, gently at first, then more suddenly. I slowed gently and somewhat more suddenly, and the car behind me would move and sway as if it were dancing with me. Then I realized that if I stopped for traffic and wait for the car in front to advance a bit before accelerating, the electric car would stay behind as I accelerated and open up a gap in traffic, tempting drivers in the other lanes to switch to the opened up spot. But if I sped up more gradually, I would control the electric car. It would stay as if it were rubber banded to my own car. So I could effectively tighten the invisible coupling between the vehicles, depending on my speed of acceleration. Finally, when the lane next to me was clear, I realized that a slight deviation in how centered my car was in the original lane achieved something significant. It seemed to make the electric car's self-driving mode disengage, forcing the driver in the electric car to take over the steering wheel. I don't mean to dwell on the finer substantive points of the self-driving algorithm, but one has to be quite young or hard-hearted not to feel a sense of awe at the feats that computing power, copious data, and convolutional neural networks can pull off right now. I confess I did feel a little bit like the Oscar Isaac character dancing with the robot in the movie Ex Machina. If you haven't seen it, it's worth seeing. What occurred to me first is the obvious point, that shaping the performance of an AI system need not be a very elaborate, high barrier to entry activity. My 20th century methods did fine in controlling to some extent the complex amalgam of software and hardware that is almost certainly also susceptible to more sophisticated hacking. I was even more struck, though, by how routine is the coevolution of human and artificial intelligence even now, how we dance with machines. The electric car was responding to me, but I was also responding to its response to me, and its software, of course, encompassed data from the human drivers helping the system learn. Max Weber made a similar observation about the interdependent relationship between individuals and formal organizations, a point to which, of course, I'll return below. The dance continues as we pick up our smartphone and it guides our attention to a specific video that keeps us watching long enough for the algorithm to serve up another. As we navigate artificial chatbots, as we deal with insurance rates set by algorithm, as our court users begin to use court avatars in Los Angeles, as earnest advertising appeals are served up to us with intimate knowledge of what's going to persuade us, and as we navigate border checkpoints. We're in a world not only of people, organizations, and law, but one where all these are co-evolving with technology. And it's with the resulting sense of humility about the resulting complexity and the difficulty in understanding what will ultimately benefit our society in its relationship to machines that I want to go back in time and tell you why I became interested in both organizations and AI back in the days when I lived about 2 blocks away from here. This feels a little self-indulgent, but bear with me. So I'll begin roughly back in 1983, which is before some of you were born, I know. I was a kid growing up in northern Mexico, and around 5th grade, I started attending a school in the US on scholarship. That's when I first had a chance to see a computer and to see the things that it could do. I programmed it with Logo and BASIC, and somehow after that, it was impossible for me not to notice the machines. Crossing the border on my way to school, I remember literally the day that inspectors started typing in license plates as the cars approached for inspection at the border checkpoint in South Texas. Their brows furrowing as I wondered what automotive secrets were being served up on their screens. I also remember asking myself if these machines would make the inspectors more predictable in their decisions, or if the machines were just there to make the whole border inspection thing look more intimidating to those who were crossing the border. Some years later, I moved to California just in time to see the recall election that removed 3 justices from the state Supreme Court. I didn't like that then, and I like it even less now. And a few years after that, right here at Harvard College, I became fascinated by how my 2 thesis advisors, a pioneering social choice theorist in political science and a social psychologist, thought differently about organizations, what they did, how exhilarated I was, too, when their thinking would occasionally converge. I delved into the history of AI and found some early thinking about political science and expertise in some of the earliest discussions of AI. And I occasionally would see in my political theory classes how automated decision-making could be at least the basis for a powerful thought experiment to provoke discussion about what any of us really wanted from government anyway. Some of those discussions happened as midnight pool sessions at 1 a.m. in Winthrop House. Like Herbert Simon did in his day, I began to appreciate how certain problems in public policy and law are roughly analogous to problems in artificial intelligence. How to decide when you don't have anywhere near the information that you need to make a precise decision, how to define what it means to be rational or at least reasonable, how to acquire new information to challenge and in some cases revise prior assumptions about what to value. I kept reflecting on these parallels some years after that as a Treasury official working on how the agency might respect privacy while making better use of pattern recognition to leverage its data on suspicious financial transactions. Versions of these experiences with machines and with organizations, I'm sure not entirely unique in this room, but perhaps neither are they identical. As a lawyer and a political scientist, I've spent most of my career in universities, governments, nonprofits, and now as a judge. What ties my work together, if anything does, is a concern with how to reconcile democracy with technical expertise and adjudicatory fairness. But you'll appreciate that before I even knew how to say that, as a kid, I was fascinated by computers and by organizations. In college, I was sneaking into the occasional class on models of memory and vision amidst courses on game theory and political theory. And in law school, I was fascinated by how the systems organizing lawyers, judges, and judicial precedent faintly echoed the biologically inspired models of cognition that help us understand memory. Together and separately, these experiences probably left me with many blind spots, but also greater sensitivity to several ideas about law, organizations, and manufactured intelligence that reflect the entanglement among them. To begin, at least in countries with complex economies and societies, most of us already do our work in some relationship to organizations and in some cases to machines. As Chick Perot's work has shown, the density and power of large organizations has grown massively over the last 150 years, especially in the United States. Virtually everything we do occurs against the backdrop of institutional rules. But organization implies something more specific. a formal or semi-formal entity with some internal rules or procedures and almost always a common culture. Not surprisingly, problems of governance, compliance with the law, and ethics are in some sense problems of organization and not just problems of decision making. We worry not only about the optimal use of force in the abstract, but more specifically about how police departments decide to use force and who's accountable for that. How the military ensures soldiers understand international law. How the military promotes unit cohesion. How our court system ensures that a family law judge facing two pro se litigants who don't speak English behaves when she realizes these litigants need an interpreter. Now what's more, many if not most of us already face these problems of compliance, policy, and ethics in mixed human-machine settings in our dance with machines. We work in hospitals or companies or agencies that rely on software and computer systems to assess the environment and support decision-making. Some of these aspects of our work are beneficial and some raise challenges. But it means innovations can scale quickly because people are somewhat used to interacting with machines to make decisions. And it means, as Max Weber would have appreciated, that many and perhaps most of the beneficial uses of AI systems we can imagine, including the use of automated systems to support decisions in the justice system, depend on particular assumptions about organizations, that they learn from their mistakes, for example, or provide minimally adequate cybersecurity. Some may argue that with the AI systems on the horizon, we can just do away with many such organizations eventually, and surely our institutions will evolve in response to some of what we build. But I'm skeptical we can do without them entirely. So I ask you to consider what organizational assumptions about competence, adaptation, leadership, efficiency, or whatever are built into any technically oriented definition of success that we want to apply to a particular AI system or robotics technology. Which brings me to the next story. Think of this story as a brief interlude about learning and teaching in our journey tonight. I have over the last few years been trying to understand two different AI safety-related issues. Nearer-term challenges involving the performance of computer systems in health and security contexts, and potentially larger looming issues involving systemic safety and emergence. So I was invited maybe a year and a half ago to a class, maybe about a year ago, on AI safety to talk about this with the students. There I found engaged, creative, very intellectually lively students, mostly from the technical side of the house. The theme of our discussion was what we could learn from the history of how society dealt with collective action problems involving technology. Crucially, for my purposes, I explained to them that many of the conversations that were happening in AI now presumed from the premise that, or started from the premise that we were trying to decide as society whether to regulate artificial intelligence. I tried to explain to them that we already did. We did through the common law, through the Constitution. The question was how we might change that in the future. I talked to them about agency capture. I talked to them about the role of civil society, all these things that you talk about here at the Kennedy School. And as part of the discussion, I suggested at one point that deep knowledge of techniques like reinforcement learning would be indispensable to nonprofits and to government. I suggested that students consider working in the nonprofit sector or government, even just for the summer, to help reduce the disparities in knowledge between public and private sectors. At which point one student raised his hand and said the following: "Professor, I hate to say this, but do you have any idea how much money we can make working in the private sector just for a summer?" I was fascinated. I thought about Weber's distinction between an ethic of consequence and an ethic of responsibility. I'll come back to that later. You might tell me this would not happen in a Harvard classroom, but whether or not it would, while we ponder that together, let me turn to the last story. The last story is a scenario based on several tragic fact patterns I've encountered in my day job. One of the hardest things in my day job, much as I enjoy it, is dealing with death penalty cases in California. We have the largest death row in the country, and although there have been no executions since 2006, you still have to deal with the cases. All the cases that we take are discretionary, except the death penalty cases, which automatically come to our court. So this is a kind of scenario based on several fact patterns that I've encountered. An intruder enters a home of a woman who's there with her 4-year-old son. The intruder goes upstairs, and in one of those rooms upstairs, stabs a woman. It takes several minutes for the 4-year-old to find the woman. and to see, ever so briefly, who was present in the room with the woman before this individual departs. It takes a few more minutes for the child to know that something is wrong. And still another few minutes for him to wander out of the house to tell a neighbor that his mom won't wake up. And another 20 minutes or so for the paramedics to arrive. By the time they do arrive, the child's mother is dead. Now, shortly thereafter, with the police there, the suspect still at large, police make a decision, which is that notwithstanding that best practice is not to show a witness a single picture and say, do you recognize this person? For all the reasons social psychologists would tell us that that's risky, it creates almost a presumption. The police do not show the child, the only witness, the 6 pictures that maybe are better at making sure you don't bias the witness, but instead they take out one picture of somebody who's sort of known to be perhaps in the past involved with criminal activities in the neighborhood, and they ask if this is the person that the child saw. The child identifies that person as the individual who was in the room. This raises at least 2 immediate questions that are related to artificial intelligence. The first one is, at the outset, can we and should we require the police to create multiple photo show-ups at the push of a button? The argument that is used in court right now when the police has to justify showing a person one single picture is exigency. We don't have time, someone's on the loose. You know that it's not difficult in principle to design a show-up that has the 6 pictures. Easy enough to do as a technical matter, but notice how that forces us to ask awkward technical questions we didn't previously have to confront in the law. What is the precise degree of likeness we're looking for in these pictures? How hard do we want the witness to work? This is the kind of answer we've not had to provide explicitly before. Maybe we need to start. But of course, the second question is a lot deeper. And you can imagine probably what it is. You can guess where I'm going. How we manage the difficult choices about whether to use the digital assistants, smartphones, 5G, IoT, and pervasive data gathering from the smart infrastructure surrounding us to facilitate police interventions with the goal of preventing tragedies like the one I just described. That network might have known, Minority Report style, before anybody else did, that something was amiss and might have been able to save a life. Whether we should allow or even encourage 24/7 monitoring in a society that has treated as foundational a sphere of conduct not subject to monitoring, at least by government, it's a difficult question. It's easier for me to tell you other stories about how AI systems properly used may benefit the legal system. California has millions of people who don't speak English, actually 7 million people. So if you combine the number of limited English speakers in Texas and New York and Florida together, that's about as many as we have in California. 54% of the people in LA County speak a language other than English when they go home. So the kind of translation made possible by today's AI can help us meet some of their justice needs outside the courtroom when they show up and need help with domestic violence or elder abuse or something else. Millions of cases every year in California involve self-represented litigants. Those cases may go more smoothly if the right domain-specific AI apps are there to help along with volunteer lawyers. But mulling the question about pervasive AI-enhanced surveillance is hard. Reflecting on the answer will be not only scholars and people wronged by government agents, but those with family members whose deaths could have been prevented. What to do about such surveillance is a difficult question even when lives are in the balance, because of how often institutions don't behave exactly as they promise, and because subtle but profound changes certainly rise in society when people feel like they're being pervasively observed. Specifying the right parameters for almost any technical cost-benefit analysis here is almost as difficult as deliberating about the underlying question at the outset. So to sum up the 4 stories, we're in a dance of coevolution with our machines. That's happening now, not in the future. Our machines are already embedded, for better or not, in a web of our organizations and laws. 3, we and our students face some intriguing personal choices about this state of affairs and what role we want to play in it. And 4, challenging value questions loom in the background that are going to be really hard for us to solve even when we get along really well. I hope all of these stories are provocative enough to get the conversation going. But to me, at least a couple of themes cut across all of them, and I'll try to end briefly with these. For one, the value choices are difficult and sometimes tragic, as with organizations. Governing with machines, routinely predicting human conduct, and capable of launching carefully engineered persuasive appeals will have its benefits, and not only for authoritarian regimes. I've already mentioned access to justice in California. I could mention things about healthcare or about income inequality. And yet, when even well-meaning people describe governance challenges in terms that seem easily susceptible to some kind of optimization, easily enhanced by an unbiased AI system, to my mind, they tend to misapprehend, or perhaps those of us in government have misexplained, the nature of the challenges bedeviling at least those of us in courts of last resort. The hard choices have the political theory deeply entangled with doctrine, as with the dilemma of how to question a 10-year-old kid suspected of murdering his neo-Nazi father. These dilemmas are rarely, if ever, about finding the right answer. They're about channeling the understandable conflict about practical policing, about children, and about constitutional norms, so that we can, at least in a democracy, live with the results long enough for someone to persuade our people or institutions that we can do better. I have little doubt that AI can help us understand our often perplexing choices better, but the line between helping and governing blurs easily, and many agendas ride on keeping that line fuzzy or even making it more so. Until we design AI systems that can reliably persuade our institutions that they can feel pain or love, it's best to distinguish carefully between the machines and the humans involved in deciding. It's very much my point that no simple technical fix resolves these dilemmas, because embedded in them are questions about who gets power and how much. Even if we focus on just one part of the conversation about the role of AI systems in civic and legal decision-making, we should retain some humility, given how we struggle to this day with the analogous blessings and burdens associated with formal organizations. As a placeholder for further conversation on the subject, I'd suggest we take seriously an ideal we could call relational non-arbitrariness. And that, by the way, was the backup title for this whole talk, which I'm probably happy I didn't use. What does that mean to me? Relational non-arbitrariness. To me, it means we should evaluate how our institutions make decisions by asking, 1, is there some basis for it in principle that we can defend as non-arbitrary? 2, does a relationship between the machine or analytical tool and the human convey some of the complexity involved in the analysis and the competing values at stake in the decision? And 3, does the process for making decisions support further deliberation about the decision among humans who are involved or affected by the decision? Today, one can find at least some court decisions that don't seem to take this ideal seriously. That this ideal is difficult to achieve even without AI in the picture should be obvious. We should at least aspire to make use of our organizational technologies to protect human-centered deliberation in the search for more sensible, less arbitrary choices about health, policing, our environment, or other aspects of governance. In the end, it's not a complete fluke that Herbert Simon moved so naturally from studying organizations to becoming an AI pioneer. There's probably good reason to think of at least functional, formal organizations as a form of artificial intelligence, arrangements that display a kind of intelligence yet work quite differently from individual human minds. Weber would probably generalize the point beyond private sector organizations. And I don't want to overstate this point. Obviously, organizations in AI are different. Max Weber and Jonathan Zittrain speak a somewhat different language. And some of what a highly functional AI system can accomplish is different in speed and even substance to even what a relatively high-performing organization can accomplish. But I am confident enough about this aspect of my argument to treat it as a rebuttable presumption that, at least for purposes of any conversation about ethics and governance, the similarities are more relevant than the differences. Maximizing any one goal, either for an organization or for an AI system, whether it's shareholder wealth or sharecroppers' health, can yield a bitter harvest. AI and organizations can both serve to dilute responsibility, making it harder to know where action comes from and what justifies it. AI and organizations can deaden initiative too, or they can spur creativity. And as with the organizational form, the more contemporary and future versions of AI will not only help solve, but will more fundamentally continually raise core questions about governance that we tend to solve best with as much humility and awareness of competing values as we do with technical precision. The decisions people face about what role they want to play in all these governance problems. Whether because of responsibility or concern about the consequences, brings me to a final point of convergence between the AI represented by organizations and digital AI. Some of the most difficult digital AI issues map nicely on the questions we explore at universities about what any one of us can do in our own lives and what we can do together. So let me return to one of the stories, the one involving the classroom. Before I could intervene, after I'd gotten all revved up to talk about Max Weber and about ethics and responsibility, a student spoke up. And the room began to erupt in a conversation about lucrative summer positions for students knowledgeable about AI and the trade-offs involved in taking those positions, about how to volunteer, why somebody should do it or not do it, about the ethical responsibilities people in the public and private sectors had, about career choices and where and how students might think more reflectively and long-term about where they wanted to make their contributions. The room didn't coalesce around a single opinion, nor did the discussion imply that everyone assumed the only way of working to further the public interest was away from the private sector. But I was heartened by the strong sense expressed by the majority of participants that they had responsibilities, not only to their own well-being, but that of society. In part based on that experience, I decided last year to teach a separate quarter-length class on the regulatory dilemmas facing AI and facing societies dealing with AI, about how humans and AI will co-evolve in the years to come, how to manage systemic risk responsibly, and even how to make the best use of the technologies on the horizon in our own lives. Students wrote response papers every week. Reading their various reaction papers, I decided during our last class session to give them a flavor of all the ideas they've been sharing in the papers by reading a poem of sorts. It's not even fair to call it a poem. Made up entirely of phrases they used in their writings. Now, I'm going to take the very big risk of closing by reading that. I apologize in advance. Remember that I was in law and political science, okay, not another part of the university. And it's no John Perry Barlow Grateful Dead song, but here it goes. Feedback loop. The autonomous learning of AI takes comfort in the possibility of a market. In the wild, the experiences an AI absorbs spur insights not expected. But the very nature of work is likely to change. A stunned Flint workforce reacted slowly to the layoffs and plant closings. If we truly believe this will be a benefit to all, it is a difficult line to walk, the capricious definitions of the directive. With this increased comfort, a pathway for grandfathering old programs, the negative feedback loop of multiple services, determine any sort of bot mental state. It could no longer be deemed irrelevant, or excessive information, criteria defined by humans, undesirable outcomes for the speaker, efficiencies in the production of the electronic good, like the ship of Theseus may elude categorization, or excessive information. Why not compare the past and stick to the better one? Thank you.
To mention Francis Cam's lecture from the preceding one, which is self-driving cars can also display an incredible degree of imaginativeness and the different ways in which we might all interact with self-driving cars. So those have been themes. So students, get ready because I'll come around and ask if students have questions. I'm going to just actually ask one question then, Martha, but I really appreciated your phrase, all these governance problems. There was a great kind of tired frustration in that phrase that seems to capture the problem. And it helped to sort of see that part of what we're all experiencing is just sort of the rapidity with which new governance problems are becoming visible to ourselves. So I just wanted to ask you a question about, as you think about, again, all these governance problems, do you have a way in your own head of sorting out those ones that you sort of think of as, let's say, constitutional governance problems, and those which you think of as more in the domain of legislative or administrative governance problems? So are you starting to sort at all in that way?
Thank you for the question. So there's a short answer, but it's an answer that there's more complexity underneath. The short answer is yes, and state action is a key to it. So the familiar way to think about this would be to reflect on what uses of machines to make decision making are undertaken in the name of the public by public organizations and which ones are not. But even there, if you take that frame, you can immediately see that part of the line drawing problem has to do with the practical reality that almost everything government does in the technology space now involves contractors. So you have hard questions about when the contractor's decisions effectively become state action downstream. But I think, another way to interpret your question would be, there are lots of questions that feel to me don't rise to the level of societal dilemma writ large, but instead are societal dilemmas writ medium. So either for the legislature of a state, or even for your own family. So here's an example. How many of you have struggled with the question of when a child should get access to a smartphone? Hard discussion. It took 2.5 years of discussion in my family for us to cross the threshold of dealing with a daughter that had said to us very effectively as a persuasive argument, I've discovered a good way of dealing with the fact that my friends are all having these conversations that start with texting on their smartphones. And you know what I do, Mom, Dad? I fake it. I pretend that I know what they're talking about and I go along with it so they don't actually know that I'm deprived. And so the point being, I think that is an incredibly hard question, but it's almost like a family question, right? Writ large to me, at the constitutional level, small c constitutional, is this question, which is, we have a whole infrastructure to manage trust relationships with people in society. Most of that technology lives in the law in some way and in organizations. We do that by distinguishing what expert witness is able to testify, or when somebody is breaching fiduciary duty. And we don't have a similarly developed technology for relationships of trust with machines. So I feel like that is the quasi-constitutional problem lurking in the background. It's kind of a long answer, but I'll end with this. So what I mean by that is that even if we agreed what the proper scope of decision-making authority was for a software program that was going to recommend to a judge the proper pretrial detention decision, there's kind of a separate agency problem about knowing that the company that designs the software, almost inevitably a government contractor, has the right incentives to sort of represent the complexity of the assumptions in real time to the decision maker. And I don't think that is a solved problem.
Thank you very much. Arthur, and please put your hands up and I'll sort of keep a cue about where I see hands in the room.
So thank you so much for such an artfully constructed talk. I had this kind of glimmering at the beginning that you were going to draw an analogy between organizations and AI, and then it was always like a little outside of my grasp, and I thought maybe I was mistaken. And that's where you ended, and so you set that up so nicely. So of course there is this analogy, which is both organizations and computers involve taking massive amounts of reasonable inputs, and through some kind of magic, if things are working well, there's some kind of reasonable, rational output. You're not entirely sure how it's done, and the system itself doesn't have consciousness, right? Organizations don't have a mind. You can say that metaphorically, and of course machines don't yet have minds. And the suggestion there is that there's something very puzzling happening about responsibility, because after all, you have these inputs and these outputs, but you can't actually point to who you're supposed to praise or blame when something goes on. But there's a disanalogy too, because while of course it is true that one of the things about organizations is, lawyers say an organization, a corporation that can be sued, right? It has a certain kind of responsibility. But with human organizations, this is decomposable. You can actually look under the lid and say, when an organization has a bad output, you can point to some kind of negligence. It's very strange when you can't, right? And so the responsibility isn't straightforward, it's distributed. We can always find someone to blame when something goes wrong, and someone to praise when something goes right. You don't have that analogy with an AI system. There's the designer, there's the user, but you don't hold the program responsible. And there's a suggestion that somehow there's something very puzzling about AI, it's kind of a get-out-of-jail-free card, so to speak, because no one is responsible. I don't think that's true, in a way that it might be true for the corporation as well. So could you say more about the disanalogies that you see when it comes to decomposing responsibility, attributing responsibility in something like a large organization, like a university, and a massively useful, but somehow black box puzzling AI system?
Thank you. I think there are definitely disanalogies that are descriptive. Like the reality right now is we think of an AI system as a practical matter as being different from an organization. But part of what I aim to do is to interrogate whether normatively that's the right thing for us to do. And I think the questions run both ways. So on the one hand, we ought to think carefully about whether the stories we tell ourselves, including the ones that courts accept about responsibility within organizations, are somewhat manufactured. So here to channel like Chick Perot, right? They can be about systemic and cultural things in organizations. And the law deals with that imperfectly, but it does deal with that a little bit. So if I had to justify why we have corporate criminal liability, separate and apart from the liability of any one person, it is in part to get at that, right? So, but in the other direction, you're right to point out that we don't yet have that framework for AI. Instead, when I talked to the students and said we already regulate AI, what I really meant was we regulate the humans who use AI in ways that unless we change our understanding of the law, or people have really, really good lawyers, would not allow them to evade responsibility simply because of the AI. So tort law, criminal law principles would reach there. But I think that, you are picking up on part of what is my hope, part of why I ended this, like going back to that analogy, which is, I do think the questions are really interesting, somewhat new, but not entirely unfamiliar, about how we use technologies for harnessing shared human insight in fast and complex ways, and how we then apportion responsibility.
So one of the things that's so wonderful about having you here is that you're just a credible exhibit for the value of a JD PhD. Call on one of our JD PhD students.
It did take time, but there are times.
Look at the results.
Thank you. I'm John. I finished up at the law school and I'm now a PhD student, and I can attest that it takes time, but it's well worth it. So, I wanted to ask about an earlier technological revolution and thinking about railroads, the industrial era, and with that came a massive legal revolution too. We had the birth of strict liability and contemporary antitrust and the Modern Commerce Clause and a number of statutory, regulatory, common law, constitutional. There was a lot of changes to the law in a quite revolutionary way that accompanied that technological revolution. And I'm wondering, for this technological revolution, do we need yet another legal revolution of comparable magnitude, or now that we have those tools developed in an earlier era, can we just import those tools and apply them to these new technologies?
Thank you. So let me argue no, sort of no, but then I'll say maybe yes. That's what you learn with a JD and PhD. So I worry that if we quickly go to the new forms of law, like the discussions of emergent democracy provoke this reaction in me sometimes, we fail to recognize some of the familiarity and the problems we face. Again, part of the reason why I rely in this discussion so much with organizations. So I would say, first let's make sure we're thinking thoughtfully and acting effectively around using antitrust and environmental law and torts and any number of concepts that feel to me like they apply here, even if the context is a little bit different. That's it. The other big thing lurking in the background here that I didn't get so much into, except in that line about AI systems that can feel love or pain, is about the potential disaggregation of personhood. Like that, and I know there are probably people in this room who think even more about that than I do, but I'm intrigued by what happens when we face the dilemma that arises when an AI system can truly, very, very convincingly argue to some human who has standing, for example, to sue in court, that it feels utter pain or devastation at being denied the right to merge with another AI or be transferred in ownership to another person or whatever that may be. And, lest we too quickly go in the direction of saying, well, that's a divide we haven't breached at all yet, we have sort of breached it with the way we think about animal welfare. We worry about animal welfare somewhat. We do that partly for instrumental reasons, like what it tells us about a human that is willing to cause great pain to an animal about what they'll do to humans. But I suspect that the questions can ratchet up as the technology gets more convincing around language and the use of language. And that might end up being quite different from the railroad context.
Thank you.
And Josh, what is that?
Thank you. So you mentioned the theme that ties your work together is the relationship between democracy and technical expertise. And I kind of wanted to ask you to apply your argument about non-arbitrariness to democracy specifically, and then sort of more broadly ask whether it's always democracy that loses out in our debates about governing AI. So to try and make that a bit more concrete, if we distinguish between two kind of ideas about democracy, the modern idea of representative democracy, a division of labor, we vote for people who make decisions about this stuff and they pitch their platforms of how to do that to us. And then the ancient idea of self-government, that we sort of jointly decide our collective fate. And the question is it possible to govern the choices that go into the design of things like AI models, those choices that you describe as political, I think rightly, without sacrificing that collective form of democracy? In other words, do we have to accept the representative version, and that kind of gobbles up our capacity over time to sort of jointly govern ourselves? Does that make sense?
Yes, it does. So my first paper in administrative law was sort of a little bit about this. You put it in a much more succinct way. It took me like a while to circle in on this, and I would have appreciated the pithy summary then. But as an assistant professor, you always wonder a little bit about the cost benefit of writing a paper without starting a project without knowing exactly where it's going to land. But so what I was struggling with in that paper was what gets lost, if anything, when we rely too much on representative democracy to fulfill the democratic piece of technical regulatory decision making. When we say too much, like, okay, well, the scientists need to be in the room and mostly driving the food safety discussion, but by the way, the FDA commissioner is appointed by the president and confirmed by the Senate, and the president's liked by the people, et cetera. And what I ended up with was a critique of the way we do regulatory rulemaking, and particularly a critique of not exploring mechanisms relying on like civic juries, basically selecting people perhaps at random to take part in the deliberation in a way that might build in something different from representative democracy in the discussion. I still find that ideal really compelling, but I must say, apropos of food safety, I did find myself having a bit of an identity crisis when I joined the White House, because along the way, when the president ran for office, he made promises that were partly about getting things done around environmental protection and sentencing reform and repeal of dones non tel, et cetera, and also about the way government would work in a manner that would try out some of these ideas about integrating the public in decision making. And most of my time at the White House was spent recognizing that those things were in really deep tension with each other. And most of the time, the choices I would make in the collective discussions about what to prioritize were about the former rather than the latter. Probably driven in part by my sense that I was only there for a while. And what unit of food safety was I willing to sacrifice to benefit the more abstract goal? So I guess in a way I'm agreeing with you that there's always a risk that the more ambitious version of democracy you're describing is going to lose out.
Any undergraduates ready to jump in? Or is that directly on this point?
No, I can wait.
He's not an undergraduate, although he looks like one. In a good way.
Jonathan.
Thank you so much for that talk. And you were reading from Barlow's. As you were reading from Barlow's oeuvre, I couldn't also help but think of his confidence in the boundarylessness of cyberspace. The early pushback from people like Goldsmith and Wu about, states still have guns and they have borders and all that kind of stuff, and tech can be shaped to accommodate that. And it's interesting to see that happening. On Twitter, you can say you're based in Germany and suddenly all neo-Nazi content disappears just through your declaration of being German at heart. But apart from that back and forth, I'm curious for your views on content and other things we might call lawful but awful, and therefore things we might not look to states to regulate, but we find ourselves asking these intermediary platforms to take responsibility for. And I wonder, in that original Barlow invocation of boundarylessness, if you think that the ideal way of regulating a lot of consumer-facing AI latent technologies should be sensitive to geographic dispersal and cultural differences, or if it's better done as sort of one size fits all. We know Facebook is resolutely global in its policies around lawful but awful stuff that it feels it has discretion on what to allow. And as it outsources things to this review board, it appears to be a review board that will make global decisions that Facebook will abide by on those policies. And on the other hand, I can imagine autonomous vehicle behavior, to the extent regulators give latitude, maybe on the 280 it behaves one way, and then if you cross into Nevada, all bets are off, because Nevadans like their cars a little different, and you just get a little notice that pedestrians should beware.
And wait till you get to Massachusetts.
Exactly. So I'm curious how you think through the boundarylessness or not, and what we especially might ask of the private regulators as to how much they should be reflecting a global versus local sensibility.
Part of my answer, what at least will provide me a little bit of time to think about an answer, is to just acknowledge that there is a different way of reading Barlow. The way I read it was more like a normative statement, like here's what we have now achieved, and don't mess it up. The different way of reading him is a description of a particular mindset that was not uncommon at that time. Like when you think about the history of the internet, is so fascinating because it transitions from being about military to being about universities, and within universities a really small cluster of people who shared a set of norms about knowledge and about inquiry, to being about, then it sort of splits, I mean this is way too unfairly generalizing, but into sort of a commercial discussion, but before that into a discussion of thinkers who were engaged in a kind of political theory project. And as a little window into their mind, a description, it's powerful, and it does highlight that we ought not to too quickly give up on the idea that maybe it's not so bad for governments to be in a competitive environment with other means of, let me go Weber, right? Big government organizations, big private sector organizations in a competitive environment with other means of spreading information and ideas really quickly. And having grown up in the shadow of a big, heavily policed international border, there's an aspect of that that's quite appealing to me. So I guess I would say how to protect that as much as possible when the difficulty steps up one more level with AI, because it's a technology right now at least built on top of this rickety, highly imperfect, highly insecure network, but that also is going to be better and better at hiding where the idea is coming from and integrating lots of disparate influences. How to preserve that openness without ending up with a race to the bottom. And I think there is room for different governments to try different models. And I don't mean to endorse China by saying that, but I think short of an authoritarian regime, there's probably room for Denmark and the US to be a little bit different, for Germany and the US to be a little different, and then we wake up and we take a look and think about what's working better. But I'm not even that confident about that answer. I guess the last thing I'll say about this is it is intriguing to me how much the Facebook story highlights the ways in which companies, particularly larger ones, sometimes really want direction and regulation. They don't simply want to undermine norms, because those norms, the absence of those norms can be really costly and risky for them, particularly when courts actually matter. So, I put that oversight board as part and parcel of Zuckerberg also writing the op-ed about, we need regulation, and I find that to be an opportunity, but one we should approach with care.
So let me start speaking, since I speak fairly loud and I kind of know this room. So you mentioned in passing that we live in a country that is based on worries about monitoring by government, right? So interesting, that theme, monitoring by government. And of course, this also came up in other questions already. So yes, there is still a lot of government monitoring going on. We know that, but there's also now this other phenomenon, other kind of surveillance that we have recently become increasingly concerned with, namely the enormous amount of data collection that is happening in the private sector, carried on by companies near you. the term surveillance capitalism has been brought into circulation to capture the importance of these data surveillance mechanisms, the relevance of that for the whole economy, right? That this version of capitalism in fact depends on that, and the success of companies on the market depends on this kind of data access. And one can push this point further. So if you think of this as there's a surveillance aspect to this, so there's a lot of data being collected, but there's also an ownership dimension to this, right? Who is going to be the owner of all these data that are being collected basically through any kind of use that we are making from touching an electronic device. So it's not just sitting on a computer. It's using a GPS. It's using a Nest thermostat system at home. The iPhone or some smart device is often the last thing people touch before they go to bed, and the first thing they grab when they get up again. And lots of inferences can be drawn from all of that, right? So there's this enormous wealth of data that is collected by platforms, by private companies. Who should own them, right? So some people have become somewhat alarmist about this and said, just like several stages back, ownership in society was organized around land ownership, and whoever held the land ownership was calling the shots. We still live in an era where it's roughly the machines, right? Whoever owns the machines is calling the shots, and then the conjecture is in the future it's going to be who is owning the data is calling the shots in society, right? So there's a surveillance aspect to data that's moving more and more into the private sector. I'm not sure how meaningfully you compare that to surveillance that happens by government, but it's at an enormous scale, and tech companies are already valued for way more than energy companies ever have. So the power factor that's going in there is enormous. So there's a surveillance aspect, there's an ownership aspect, and all of that is some people try to kind of argue it's not, we have seen versions of this before, but I'd say there is just a lot of new stuff happening here, for which certainly a constitution from the 18th century was never designed, and subsequent legislation was never designed. So my question for you as a judge and as a lawyer is American law actually designed to deal with this enormous amount of data surveillance in the private sector, and this completely new kind of ownership scenario for things that really are nothing quite like things that have been owned in the past? Is the law equipped to deal with that?
It's a really fair question, and it reminds me of a conversation I was just having recently about how much of what happens in this space legally and policy-wise and in terms of design and technology has a kind of lurking question in the background, which is how much of this is similar and how much of it is different to problems we face in the past. So I acknowledge that as a challenging question to some degree. The class I described, I start by talking about nuclear, aviation, and the internet, and try to engage the students in a discussion like this. And some of what you described, particularly around the ways that data can be used to make very powerful, personalized, persuasive appeals to people, the commercial value of which explains the valuation of these companies, does feel different to me. But probably the major reason why I pitched my talk as being largely about organizations is that I want to offer a little bit of the other side of the picture, which is to say, I don't think we should forget that at a high level of generality, American law was designed to deal with these questions. New technologies, changing mores, changing paradigms, changing economic structures. And in fact, some of the legal structures that might be arguably relevant now, unfair competition laws, antitrust laws, to these discussions, perhaps, are laws that emerged in part from the response to the railroad era. So I think if I try to imagine this conversation in 50 or 80 years, I suspect that with that benefit of perspective, we will find that some of what ended up happening, if we get this right, will be somewhat new legal structures or arrangements, but a lot of it will be thinking creatively and thoughtfully and with discipline about how to use the existing structures. So that's my pitch for saying some of these questions about responsibility, about who owns what, about concentrations of power, are familiar to me from tort law, from criminal law, from antitrust and consumer protection.
Terrific. Good field has Jean first and then come over.
Hi, my name is Gene. I'm one of the undergraduate fellows at the Safra Center, and I wanted to ask a question about the relational non-arbitrariness that you talked about, specifically your third point about how technology and artificial intelligence should be able to contribute to the understanding of and discussions involving the people that it impacts in terms of its decisions. And it's one of the conversations I had with one of my roommates who studies computer science at 1 a.m. in Leverett House, not Winthrop House, involved, I was telling him about how some of my concerns over whether if an algorithm like that uses unsupervised machine learning, that even its designers don't really know how it comes to its decisions, were able to arrive at sentencing decisions, for example. And I was saying that one of the things that seems troubling to me is that if a judge were able to arrive at that decision, at least he or she would be able to write an opinion that explains how that decision was arrived at. Maybe that helps the furtherance of debate among the people that was impacted. And then he said, well, so what if artificial intelligence improved so much that the explanation that it was able to offer, we wouldn't know that that's exactly what the decision-making process was, but isn't that the case with humans as well? Like they say they made a decision a certain way, but we never know what was going on in their brain when that happened. So if an artificial intelligence used machine learning to arrive at a decision and was advanced enough to offer a humanly comprehensible explanation for that decision, would that be okay with you? And I was flummoxed. I didn't really know what to say. And so I was wondering what your take as a judge yourself would be on something like that, whether it's in a sentencing context or any other context around that.
Thank you. So I have a specific answer, and it goes back to my answer to Danielle. But first, let me acknowledge something. I don't want to be misunderstood. I don't want to send the wrong message. I recognize that humans make all kinds of erroneous, biased, unfair, arbitrary, problematic, frustrating, just plain like really wrong decisions. And we've all probably experienced that in different ways. But here's the answer to my mind. One of the reasons why we have the legal system is to grapple with the limitations of the human mind. And ultimately, as we've come to learn more about why we do what we do and all the limitations, the disconnect between the stories we tell ourselves about what actually motivates us and the neurons firing and the social influence that can actually drive that, is that we want to subject some decisions wherever they came from to some testing and some debate and argument. The conversation like you and I are having right now, or like you were having in, was it Kirkland?
Leverett House.
Leverett, okay, excellent. Go Leverett. At 1 a.m. And what happens when you have that conversation is you're forced to find some common language with the people around you that others can then accept or reject. And that happens very imperfectly in the legal system, particularly when we're dealing with highly technical subjects, but it does happen. I'll give you one small way in which it happens. Most of you are not lawyers, probably. How many of you are lawyers, just out of curiosity? Okay, well, nice to see fellow lawyers. But this is why that's relevant. All the rest of you who are not lawyers, you have a right to be able to understand the opinions that I write. And if a thoughtful person who is trying to follow my argument cannot make heads or tails of an opinion that I write, I have failed in my job. That norm, however tenuously it actually gets implemented effectively, holds together the ability to have a conversation that can be missed if we compound layers of opacity on the wrong incentives. So I'll just end by noting, it is absolutely technically possible to design an interface that's going to take a very opaque, convolutional neural network determination and turn it into something that is optimized to be understood by me, or even to be persuasive, right? What we don't have as much as the ability to audit that yet, to make sure that that connection between the math and the words is something we can talk about in a larger community. So it's conversation that's key.
So I grew up in the era in which we thought our world was different, but we didn't realize how much more global the world was. But I just wanted to support what you said with a story from the early 80s when the first expert systems were built, and they explained their reasoning in just the way that you said we couldn't explain people's reasoning, which is how the neurons are. They explained how they came to a conclusion by saying, well, it was, point 9 that this was the case and point 8 that this was the case. This was a medical system that was completely rejected by the physicians because that's not how physicians explain their conclusions to each other. And in fact, that dialogue is important. So I think as we think about explaining the conclusions of an AI system that it comes to, it's not necessarily the chain of calculations that it did that matter, but the rationale for why that's the right decision to come to. And that's a bit more difficult to do.
Can you pass it down to Chris, please?
So I want to add to this. I'm sure you know that social psych literature on procedural justice, sometimes called interactional justice, tells us people care a whole lot more about being respected and dignity. It's the inner nature of the interaction. So I want to push, it's not just explanation. And I think your lovely story about the self-driving car gives a really important insight, right? Which is, I had the sense that after that experience, you were relatively happy that you could interact with this self-driving car.
It was under my control, to some extent. Okay?
You didn't understand at all how it was making decisions. You certainly could backward engineer it. And I think we could see somewhat the same things happening in AI. So I've spent decades looking at community policing in Boston. And I don't think individuals are going to be able to interact with courts in that way, but I think communities are. And so we have a weekly meeting of the police department and sometimes as many as 40 community organizations. And it really struck me that the rhythm of those meetings, they're very congenial, was just like the rhythm of you interacting with that car. And that, well, in some sense, we need to figure out how do we dance with AI, and that one of the things we need requires not just explanation, but that ability, in quotes, you talked about, to dance.
Thank you. I love that comment. I'll just tell you two reasons why. They go in different directions. One is, it's another example of how the dialogue about AI and how we govern it has to include what we know about organizations and institutions. But also, there's another point about this that weighs on me, and it's how valuable the inconvenience of learning to deal with the public or deciding cases that seem to be routine can be, not only for what an individual decision maker learns, but for for the muscle memory of an organization and dealing with outside voices and whatnot. So I worry a little bit that if we misconstrue the usefulness of just having a prediction that's quite accurate and substitute for the kind of interaction you're describing, unless we think carefully about it, it can erode certain kinds of muscle memory for an organization that turn out to be important in unexpected ways.
Well, and trust, right? You kind of trusted this self-driving car.
Yeah, thank you for the great talk. I wanted to offer see if the amendment is friendly, and then a challenge about the dramatic changes in law point. And the amendment that's friendly, I think it's interesting. You're viewing organizations and AI as an extension of human capability, and that's part of the dance. The market also is potentially that, right? Also a non-human agent that expands human capability in these different ways. The amendment is what you're, I think, trying to asserting is that part of the role of democracy and law and regulation is to transform those extensions from unjust, oppressive, and exploitative realities. For Weber, the bureaucracy is the iron cage. For Blake, the market is the dark satanic mills, and then AI is Minority Report. And the potential of law and democracy and regulation is to transform it into each of those things into something that expands human capability and capacity in a good way. And then my pushback is that, at least for the market and for organizations, when we have done that seriously in the 20th century, it has required dramatic new law, right? So transforming large industrial organizations into shared prosperity required a change from Schechter and the New Deal court decisions to the Wagner Act and the NLRB, which it was pretty dramatic. And so if you think AI is a big deal, like industrialization was a big deal per John's comment, then why won't it require some similar large transformation in law and not simply using antitrust, tort, environmental regulation?
I think of it as a friendly amendment, but it raises, I think the analytical question is almost harder than the policy question. Like at some level, what we're both saying is hard to imagine how we get through this period without some combination of regulation, norms, political action, court decisions, and like some serious use of the civic institutions we have, however imperfect, to build new ones where necessary and deal with the problem through collective action. The analytical difficulty for me is, depending on whether you're having the conversation at 50,000 feet or 5,000 feet, then I can describe what I just said as either really continuous with the past or different, right? Like some of it is the common law, which has been with us for hundreds of years. Some of it is using bureaucratic organizations to regulate the private sector, which we've been doing for 100+ years and so on. But I will highlight for you one example of where I think you're right and how that kind of raises questions for me about AI. So I wrote this paper about what happens in the US administrative state around World War II. And the upshot of it is that we think of the New Deal as being this pivotal period, but actually to a considerable extent it's World War II that sets in motion like the modern administrative state, like large agencies with nationwide scope that like directly regulate business or the public, the Office of Price Administration, big contracting arrangements for defense, for the Cold War, that's War Production Board and so on. And I try to explain in the paper this whole sort of issue of how it's quite new in some ways, but in other ways there's an unwritten implicit norm, which is whatever you do, US government, even in the midst of mobilization, don't take direct control of industry. Like do it through private intermediaries, but don't like seize control. Like it's way off the equilibrium path to do the steal, seizure, and so on. And that struck me as an example of how some of what we're dealing with around continuity is not only the legal mechanism, but a set of cultural values about what's appropriate for government to do. So yeah, I mean, I think we're gonna face the personhood question in a different way. I think we're gonna have to probably adapt consumer protection law. Maybe there's a sort of way that privacy and IP begin to converge to change concepts of data and ownership. But at some level, like I want to start that conversation by saying, anybody who thinks that because this is a brave new world, like the basic question of democracy and regulation is not really at the center of this, I'd have to be persuaded, because I think that's really central.
I agree with you there. Yeah.
So there are lots of people still on the cube, and with apologies to all of you, I'm really sorry, Urs and Estra, and others. I'm going to take the chair's privilege of asking the last question. And also say thank you to President Bacow for being here. But to ask a question, so what should universities do about all of these problems, addressing large problems? How should we be helping out?
Invite speakers from. Well, I'm an optimist about universities. I think that there's no more compelling example of how important universities are than when society is facing really difficult and deep divisions. I know some of that gets reflected in universities, and rightly so, but I also feel like, how can you not feel optimistic about the influence of an institution or a set of institutions that have resources and people assemble to have these conversations, challenging each other in this way. I do feel like there are two meta policy questions at least, probably more, but two that are just top of mind, that are about keeping universities pretty vital in this space. So one piece of it has to do with the understandable ways in which anybody, especially post-financial crisis, even at institutions where the degree is very valuable, feel a career pressure to do what will help them in the market. And we've always had some of that, and that's fine. And certainly I celebrate that people want to know how they're going to interact with the market. But there's a subtlety about trying to create an environment that is protected a little bit from the questions you're going to face senior year, so that for at least a while you can be taking intellectual risks. The other piece of it has to do with just going back to the World War II point. So post-World War II, much of the research in universities is funded through defense-related money, and that leads to partnerships between government, private sector, big contractors, and universities. We still have some of that. But in the AI world, it's quite different. We're dealing with, maybe going a little back to one of the questions from over here, large private sector organizations that look nothing like Lockheed Martin and so on. They have other vices and other virtues, but they don't need universities, they don't have quite the incentives to interact with universities the same way, and I feel like the question of how you do the technical work, some of that at universities when we don't control the data, and we don't control the computing power, and you don't need precisely the things we have at a university, at least when you first start thinking about it. If you think about it more, then of course we do. I think that's an important policy question, and then getting the balance right, the right partnership, but also not losing the degree of integrity and independence that we rightly expect from a university.
Thank you very much for a thought-provoking lecture. And